Thank you, Priyanka. Thank you so much for your wonderful moderation. Distinguished guests, ladies and gentlemen, whilst it is an incumbent task upon me to extend on behalf of the Bangladesh International Mediation Society the warmest welcome to all of you. It is also with great pleasure that I am able to join you virtually on this very eventful day. As Priyanka has indicated, my task today is not a very challenging one. I am to welcome you all to this valedictory session of the 40-hour accredited mediators training. And together with this celebration, we will be having a ceremony for the Gold Medal Award to Honorable Justice Kuryan Joseph of the Supreme Court of India. A wonderful event. Mediation, as we've learned over the days, has proven itself as an extraordinarily successful settlement process when conducted by skilled mediators across the globe. Mediation is not about deciding who is right or wrong, who is innocent or at fault, and who should be declared the winner and the loser. Mediation is about looking to the future. The focus is not on who said or did what in the past. Instead, the goal is to find a practical solution and settlement that is acceptable to everyone involved in the process, considering the different interests while seeking to preserve businesses or relationships. As chairperson of the Bangladesh International Mediation Society Mediation Board, it is an honor to give this welcome address because the provision of well-trained and competent mediators meets the need of BIMS, and that's of its primary objectives. On that note, it remains for me to thank the organizers, to thank those present before you today for putting this valedictory session and ceremony together. May I also thank in advance the distinguished guests and speakers for sharing their valuable insights and expertise with the rest of us. We thank you from the bottoms of our hearts. Thank you once again, and thank you, Priyanka.
Now, as the ceremony would go, we would have proceeded with our chief guest, but we would need to tweak the schedule a bit because Justice Mittal has to take an early flight today. Evening flights, as you all know, is a bit of an issue with the current cyclone going on. But Justice has graciously accepted to be here, even though it's like at the nick of the hour. So just to give an introduction to our special guest today, Justice Geeta Mittal. She was the former Chief Justice of the High Court of Jammu and Kashmir and the former Acting Chief Justice of the High Court of Delhi, India. She is the chairperson of the Broadcasting Contents Complaints Council, the Vulnerable Witness Committee, and the committee looking into the Manipur violence issue, both constituted by the Supreme Court of India. She is the council member, Mumbai Center for International Arbitration, MCIA, and has actively been involved in promoting mediation in India. She is on the governing and advisory bodies of leading educational institutes, such as of the Law Center of the Cornell University and other national sports bodies. She is also the former Chancellor of the National Law University, Delhi. Madam, we are honored to have you, and we would like to invite you to give us a few words of encouragement. Thank you, Priyanka. I wasn't expecting to speak at this event. I think I gave a long lecture to our friends here yesterday. Honorable Justice Mustafa Zaman Ali, Judge High Court Division, Bangladesh Supreme Court. Justice Ishwar Prasad Khatiwala, former Judge Supreme Court of Nepal. His Excellency Mr. Ghanshyam Bhandari, Ambassador of Nepal to Bangladesh. Mr. Shah Manjurul Haq, Senior Advocate, Secretary of the Supreme Court Bar Association. Mr. Arif Khan, Advocate, Supreme Court of India, of Bangladesh, I'm sorry. Ms. Madeline Kimmel, Priyanka, my dear friends, now all accomplished mediators, Namaskar, I say Sat Sri Akal, as would the Sadar friends do, and Assalamu Alaikum Salam. And also Jule, which I learned in Ladakh. As I say, very inclusive greetings, relevant at any point of the day without distinction. Where you could be speaking to America or Australia. I said this to you people yesterday, but this is for the benefit of our very learned dignitaries on the dais. That, I think that we are very, very inclusive in our, and it begins from the way we greet each other. Our greetings are not restricted by the time of the day. Mediation is the need of the hour. Mediation, it should be the rule of the day. And mediation must be encouraged by every person, every authority, every body, every court, no matter what it may be. I have had the occasion to come across judges who have felt that mediation is a tool adopted by judges who were lazy and who didn't want to deliver judgments, to put a case out of the system by sending it to a mediator. But that is not so. We have learned over the last 4 years how relevant mediation is. And mediation begins not only when a party reaches a court, but mediation is a part of a day-to-day living. If you look at our own homes, you will see the mothers mediating constantly between children, between with the husband, with the mother-in-law, between sisters-in-law and brothers-in-law. In the home, mediation is a constant tool which is adopted unconsciously and without even realizing that we are adopting what is today a formal system of dispute resolution. An additional dispute resolution system, an alternate dispute resolution, by whichever name you may call it. But mediation assumes relevance in the home. There is another aspect of mediation which we haven't addressed very seriously. Perhaps BIMS will take it on under Mr. S.N. Goswami's such able leadership, which is, clear mediation. At the school level, we start training children about disputes and dispute resolution, because there are all kinds of disputes which arise in schools and which arise amongst any two human beings, be they be children, be they be adults, be they be the elderly. But if we can start honing in skills which enable children to adopt the negotiated method, the mediated method of resolution, then perhaps we will be able to introduce a lot of peace into our social systems, into our societies. Remember, it is said, Nelson Mandela said it, Gandhiji said it, there can be peace only if there is justice. And you will feel a sense of justice if both of the parties, both the disputants, understand that the settlement that you're reaching is something which you have negotiated and willingly arrived at. And the best part about mediation, you may not resolve the dispute, but certainly you leave the mediator with a sense that you agree to disagree. So even though a plaintiff and a defendant, a brother or with a brother, two brothers fighting, will not see each other's face, will not wishing each other, but having gone through the process of mediation, they learn to at least agree to disagree. That means understand that each one has a position, and you may not have resolved the dispute, but you can be decent about it, be courteous about it. So you leave the room agreeing to disagree, and therefore there is at least peace, even in the court to which the dispute goes back. So my congratulations to all of you who have completed 40 hours of training and are getting their accreditation certificates. My congratulations to Mr. S.N. Goswami and his entire team at BIMS. My great gratitude to him and to the organizers for inviting me to be part of your journey in this mediation process. I wish you luck.
And what is most significant about this training is the fact that it is cross-border mediation. So you're already looking at resolving cross-border disputes. Nepal and Bangladesh are sitting together. Priyanka, myself, Mr. George, all of us have come from India to be part of your training. And hopefully we will be all part of a system where we can look at resolving disputes between disputants located beyond boundaries. A Nepali trader supplying goods to a Bangladeshi consumer, while another supplier is located in India. And we will be able to negotiate and resolve disputes between each of them and have a forum where such agreements arrived at in such cross-border mediation can be enforced. So I wish you all the very best in mediation, in your journey through life, in your professional journeys, and look forward to an opportunity of engaging with all of you again. Thank you, Tim.
Thank you so much, ma'am, for your ever-inspiring words. Now, I would like to invite for a few kind words and share with us his viewpoints on mediation, our Honorable Justice Joseph Kurian, who is the Judge Supreme Court of India. Justice Kurian was elevated to the Supreme Court of India on 8th of March in 2013. He retired on November 29, 2018, and he began his legal career when he graduated from Kerala Law Academy in 1978 within LLB. While being a student, he was also the General Secretary of the Kerala University Union in 1978. He formally began his legal practice in 1979 in the High Court of Kerala. Within 10 years, he was appointed as the government leader. He was named as the Additional Advocate General in 1994 and was designated as a Senior Advocate in 1906. 4 years later, 1996, my bad. Justice Joseph was elevated as a judge, High Court of Kerala, and he was made the president of the Kerala Judicial Academy in 2006 to 8, and he was also the chairman of Legal Service Authorities in Kerala in 2009 to 10, and then in Lakshadweep in 2008, and the Kerala High Court in 2006 to 2009. I warmly welcome Justice Kurian to share with us a few words of inspiration. We really wish, sir, that you would have been here with us physically, but unfortunately, due to the flights, he really tried his best even till today morning. So he's joining us today online from India. Sir, please.
Thank you so much for the kind words. Mr. S.N. Goswami, dear Sister Geeta, and all the distinguished and esteemed brothers and sisters on the dais and off the dais, and dear participants in the 40 hours of training in mediation. Well, when I retired from the Supreme Court as a judge, having had maybe almost 40 years of lawyer come judge, and particularly almost 19 years as a judge in the High Court, and 3 years as Chief Justice in the High Court and then Supreme Court. Somebody asked me a question: have you undergone a training in mediation? I was shocked, in the sense, all through my service as a judge, particularly almost 10 years or over, I have been training lawyers in the court to be mediators. I've been conducting mediations myself. I have been promoting this, and I've been speaking everywhere as mediation. But left to me, somebody asked me, have you undergone a training? I realized I have not. Though I've been training people, I've not been a trained mediator myself. So I decided to undergo a 40 hours training under the Singapore International Mediation Center. My dear friends, I tell you, I realize that what I had learned that far, of course, there is some innate or inborn art and skills in everybody. And I proudly claim there is something more inborn in me, or rather which I have developed so far in the years on mediation. But the way scientifically the mediation is to be conducted, and what exactly is the purpose of mediation, and what are the dangers if mediation is not conducted properly, etc., came to my notice solely when I underwent the training. And thereafter, when I've been conducting mediations, or I've been speaking to the trainees, it had a world of difference. So I, first of all, congratulate you, the dear participants, in having had this wonderful opportunity of a formal training of 40 hours on mediation, law, and practice. Unlike any other branch of law, in mediation, practice is more important. So before I forget anything else, I tell you, dear trained mediators, to please get attached to the trained mediators who conduct regular mediation, and then have some sort of a practical training, attend the mediation sessions, online, offline, whatever it be. Because I understand under the Bangladesh international mediations, there are a lot of activities going on, and a lot of mediations are being conducted also. So don't leave the training as now you have the knowledge. Then comes the application of knowledge. The application of knowledge is more important as a litigating lawyer also. Your degree in law college does not make you a good lawyer. It only gives you some knowledge. But what makes you a good lawyer is actually the way you conduct your advocacy. This is exactly on mediation also. You must immediately, without losing time, get attached yourself to some trained mediator who professionally, I must say, professionally conduct mediations, and then get more practical training under him, and then you will have a better confidence. Well, had I been there physically, it's a situation where, man proposed, got this post. Doesn't matter. I understand Mr. Goswami has a session in a training in September, and the date also was indicated to me 14th. Though I have an arbitration, certainly I would reschedule it and only be happy to be physically there, because I would like to be in the international center once, because I've heard a lot about those centers from my Indian counterparts here, and many people who have been trained under that. And when I've been talking to the judicial officers from Bangladesh, for whom I have been a faculty, either in the Kerala Judicial Academy or in the National Judicial Academy, I've always referred to them about mediation and asked them, inquired from them about this center and its activities, and we had a very positive notes from the modes. So, my dear friends, I'm sure Sutta Gita, you might have listened to her very, meticulously on her passionate discourse on mediation, right from the baby unto the grave. She has given you the advantages of the mediation in the family, in the educational institutions where we are students, then the professional areas where we are all working, and in the litigation process also. Why this mediation is the best? You might have been told many things also, but to me, practically, I find, nobody imposes any decision on the parties. That's the most important, the sweetest part of it. In a litigation or in an arbitration, you argue, or on your behalf, lawyers argue, and somebody takes a decision and imposes it on you. Here in mediation, nobody imposes a decision. We take a decision in the best interests of our career, our life, and our future. That is the most significant factor I have learned. Second thing, the human element in mediation. See, in court process or in quasi-judicial processes like arbitration, there is no human face of the parties. It's only the paid face of the lawyers that we see generally. So, here, parties come, give vent to their expressions, feelings, they express their feelings, emotions, and, they realize that they have more misunderstood than understood each other. I have, past 20 years, I've been watching this. Because, these disputes or differences, grow quite fast because of the misgivings, misunderstandings, miscommunications, wrong communications, gap in communications, etc., etc., etc. When they come face to face, though maybe a little, expressive also, even then doesn't matter. People stand to realize the true facts. I have several examples to tell you, which I don't want to take your time at this closing ceremony because you are on the last phase of this program. God willing, on a future occasion, we'll discuss about those aspects as well. Third thing I have noted, in a litigation, everything is based on what happened in the past, right? And the law. Whereas in mediation, we always look forward to the future. It's more future-oriented. How are we going to mold our relationships and then, go forward? Whereas in litigation or in arbitration, there is a judgment or there's an award on what had actually happened in the past. And there is nothing to look forward to the future as to how to mend your ways or bend your ways, both. So this is an added thing which I have noted in mediation. And the fourth thing I have noted is actually your participation. Of course, the decision must be legitimate. The settlement must be legitimate, no doubt, not decision, settlement. I stand corrected. The settlement must be legitimate. But it doesn't prevent you as to taking any decision appropriate to your needs and aspirations on the conflict resolution. So it need not be a law-based, though the settlement must be legal. So you are not actually cabin and confined by the rules of procedure. That's one great advantage. And more so, in settlement, it gives you more, leeway. You are free to take a decision, which of course the legitimacy will be seen by the neutral mediator. And the fifth thing I wanted to tell you is that, if you have a trained mediator, whom we call, is neutral umpire in a way, a neutral third party, he will always guide you and who will always lead you and will always, help you to evolve solutions. In an adjudication process, there is no such role on the judge. Though some well-meaning judges may help you to guide you, to lead you, or to take a best decision, etc. But it's not in the adjudicatory process. The adjudicatory process is only to adjudicate and finish. Whereas in this mediation process, there's always a good guidance by a neutral person who has nothing to do, who has no interest in either party or in the subject. That's the greatest advantage. One of the fifth advantage which I saw in mediation. And finally, among the so many other points also, I just wanted to tell you, it helps a process. It's a process which helps to usher in peace. Peace in a family, peace in neighborhood, peace in society for 2-3 reasons. One, there is a settlement of the existing disputes. Two, there is also a settlement that there shall be no future disputes on account of the issue settled. That is the greatest thing. No? In any arbitration or litigation process, you have potential for future litigations. Whereas, all possibilities of future litigations also can be conceived in a proper mediation and taken care of in a proper settlement as well. So this helps, peace and prosperity between the parties who have had some conflict. Conflicts are bound to rise, no doubt about it. In commercial transactions, in family relationships, in any partnership affair, conflicts are likely to be there. As Sister rightly said, many people may not be in a position to say, let's agree and disagree. So this disagreement becomes a dispute becomes litigation. So from the stage of disagreement to the level of dispute, and before it goes to the litigation, if we are able to find a medium of mediation for ironing out the differences, and either you end it or you mend it. Or rather put it the other way, either you mend it or you end it. In between is the litigation. So mending the ways or ending or parting the ways. This is actually the best thing I've seen, because this gives you a full stop, not a comma, not a semicolon, not a hyphen, no. This gives a finality to the disagreements or disputes or differences between the parties, and gives a quietus. And the quietus on the parties arriving at or evolving a solution themselves, and both sides are fairly happy, though you cannot be 100% happy. No process, please take it from me, no process of either mediation or arbitration or litigation, nobody will be 100% happy. But in mediation, it's a give and take. A give and take, little give up, little take also, and then you become fairly happy, and your satisfaction is the best as far as the finality is concerned when compared to an award in arbitration or what we call a judgment or an order in a judicial process. So my dear friends, these are the simple comparative advantages of mediation, and why I always prefer mediation as the best course is, you are able to save time, money, energy in a situation where disputes are bound to be there, but the way the disputes are to be resolved is the most important, and in that process, mediation is the best. Thank you, all the best, and wish you once again a very brilliant career in your profession or career, whatever it's called, as in mediation. And I wish the Bangladesh International Mediation Center all the best, and God bless you.
Thank you so much, Justice Joseph. I'm definitely going to take the very wise statement, mend it or end it. Here on, we are really looking forward to meeting you physically in September and handing over the prestigious Gold Medal Award on behalf of BIMS. A great round of applause for Justice Joseph again.
Thank you.
Now, moving on in the evening, I would like to invite our chief guest, Honorable Justice Mustafa Zaman Islam, who is the Judge, High Court Division, Supreme Court of Bangladesh. Sir, would you be generous and kind enough to hand over the certificates to the participants? Sir, please. Yes, sir. Sir, if you could come to the front. I would request the participants to come from the left side of the stage so that it's easier to take the certificate. Yes, and get down from the right. So the first one would be Mr. Deepak Rajbhat, Advocate, Kathmandu. Next is Mr. Matrika Nirala, Senior Advocate, Nepal. It's come from the left and get down from the right. Next is Mr. Pradyumna Raj Pandey, Government Officials, Kathmandu. Next is Hemprabha Pandey, Peace Activist. Dr. Hemprabha Pandey, Peace Activist from Kathmandu. Next is Professor Shashi Kumar Adhikari from Kathmandu. Next, Ms. Sunita Regni Pokhrel, Advocate, Kathmandu. Next, Ms. Lakshmi Pokhrel, Peace Activist, Nepal, Kathmandu. Next would be Ms. Devi Regni Pokhrel, Kathmandu. A big round of applause for everyone, please. Next, Ms. Sangeeta Napit, Kathmandu. Next, Ms. Simran Napit, Government Official, Kathmandu. Next, Ms. Sushma Giri, Advocate, Kathmandu. Next, Ms. Anjita Khanal, Advocate, Kathmandu. Next, Ms. Mumtaz Parveen. Mumtaz Parveen, please. Ms. Zanatul Firdaus. Ms. Fatima Sultana, Advocate, Supreme Court of Bangladesh. Please get on from the right. We just speak. Mr. Mohammed Shaful Alam. Mr. Zobair Khalid. Ms. Ishrat Hassan, Advocate, Supreme Court of Bangladesh. Mr. A.V.M. Baizid, Advocate, Supreme Court of Bangladesh. Mr. Mohammed Shafiqul Islam. Mr. Zahid Hussain. Mr. Salahuddin Ahmed. Mohammad Ruknuzzaman. It's okay. Mr. Salahuddin Ahmed. Mohammad Ruknuzzaman. Qazi Tamanna Fardush. Mohammad Siddiqui Ullah Mia. Najmi. Do we have Najmi? Okay. We know her quite fondly as Oni. Mariam Akhtar Chaudhary. Omio Mahbub. Rekha Saha. Sorry. Sajida Khanam. Mohammad Burhan Ul Haider. Tapanum Binte Kibriya. Thank you, sir. Thank you, Oli. A big round of applause for all the participants. So, introducing our chief guest today, Honorable Justice Mustafa Zaman Islam. Justice Mustafa Zaman Islam is a distinguished judge of the High Court Division of the Supreme Court of Bangladesh. Known for his profound legal acumen and dedication to justice, he has made significant contributions to the judiciary. His rulings reflect a deep commitment to upholding the rule of law and protecting human rights. Justice Islam's career is marked by a steadfast adherence to ethical principles and a relentless pursuit of fairness and equity in the legal system. His work continues to inspire legal professionals and uphold the integrity of Bangladesh's judicial system. Sir, we are honored to have you, and we would invite you for a few kind words.
Bismillahirrahmanirrahim. Assalamu alaikum. Honorable Chair of this valedictory session, Professor Dr. Mizanur Rahman, former Chairman, National Human Rights Commission, Bangladesh, who is also my respected university teacher, Department of Law, University of Dhaka, as well as Rajshahi. Guest of honor, Honorable Justice Retired Ishwar Prasad Kathiwal, former Judge, Supreme Court of Nepal. Honorable Justice Retired Geeta Mittal, former Chief Justice, State of Jammu and Kashmir, India. His Excellency Mr. Gyan Shyam Bhandari, Ambassador of Nepal to Bangladesh. Honorable Justice Retired Kurian Joseph, Judge, Supreme Court of India, who is present through video conferencing. He is known to for his human and compassionate approach to law and a strong supporter of mediation to settle their dispute amicably. He was the 10 judges in the history of the Indian Supreme Court to have delivered more than 1,000 judgments. Mrs. Madeline Kemi, Chairperson BIMS Mediation Board, who also present through video conferencing. Mr. S.N. Goswami, Senior Advocate of Bangladesh Supreme Court and Chairman of Bangladesh International Mediation Society BIMS. Mr. Shah Munjur Haq, not present, Senior Advocate Secretary of Bangladesh Supreme Court. Distinguished guests, participants, ladies and gentlemen, present electronic and print media personnel. A very good afternoon to all of you. At the very outset, I consider it a great honor and privilege for me to address before you as the chief guest of the valedictory session of the training program organized by BIMS. Thank you very much for inviting me to this session in the midst of the galaxy of international mediators and give me the opportunity to share my views with you. I know that you have already completed your training program for accredited mediators and distinguished trainers have already discussed about mediation in details. However, I would like to share my views on mediation very precisely. Mediation is a process where a neutral and independent third person, that is mediator, helps the parties in a dispute to reach their own solution. The beauty of mediation is that in mediation, each party has the opportunity to voice their own point of view. The mediator helps the parties to focus on the real issues of the dispute and explore options to resolve this. They do not take sides. The mediator does not impose a solution or give technical advice. The parties have ultimate control over the outcome of the mediation. The parties and not mediator are the focal point of the mediation process. In contrast to court proceedings, which are open to the public, the mediation process is private and confidential. Anything said or produced as evidence at a mediation session cannot be used in the hearing, except in exceptional circumstances. It is the duty of the parties to the mediation to participate in good faith. Mediators must have certain qualities, such as high standard of honesty and integrity in conduct and behavior, maintain neutrality, objectivity, and not judgmental. He must have patience, persistence, and perseverance, good communication skills, open-mindedness, and flexible in nature. Mediator, in fact, works as a peacemaker. There are many advantages of mediation rather than going for a prolonged litigation. In mediation, the parties have control over the mediation process. That is, the right to decide whether to settle or not, and the terms of settlement. Mediation is participating. Parties get an opportunity to present their case in their own words and directly participate in the negotiation. The process is voluntary and any party can opt out of it at any stage. If he feels that it is not helping him, the procedure is speedy, efficient, and cheaper. It is simple, flexible, and time-bound. The process is confidential, which is the big advantage for both the parties. There are a number of legislations in Bangladesh that have specifically provided for the provisions relating to ADR, particularly mediation and arbitration in civil matters, which are the Contract Act 1872, Section 28, the Code of Civil Procedure 1908, the Muslim Family Law Ordinance 1961, the Family Courts Ordinance 1985, the Arbitration Act 2001, the Worktorin Adalat Ain 2003, the Income Tax Ordinance 1984, the Value-Added Tax Act 1991, the Customs Act 1969, the Village Courts Act 2006, the Labor Code 2006, and Real Estate Development and Management Act 2010, etc. The legislature in Bangladesh has incorporated mediation and arbitration provision into the Code of Civil Procedure 1908 by way of amendments in Section 88 to 89E of the Code. I hope that all of you will go through it properly for proper understanding on mediation. The Amendment Act of 2003 introduces the Code annexed mediation and arbitration as integral part of the civil proceedings in Bangladesh. Later on, the Act went through another amendment in 2006 that introduced the provision of mediation at the appellate stage, and the Code was amended in 2012 that made the mediation system mandatory in civil proceedings. It was again amended in 2017 that make provision to refer the dispute or disputes to the concerned legal aid officer. Now, if the mediation is not successful, then the parties will always have the option to get back to the stage of formal judicial process, from which the dispute has been sent for mediation. If the mediation is successful, then the parties will get back the entire amount of money paid as court fees during the institution of the suit. Once an agreement is reached and executed by the parties, the same is considered to be final, and no party will be permitted to reopen the same, either by way of a fresh suit or by way of appeal or revision. In criminal justice system of Bangladesh, mediation has not yet been widely introduced. However, Section 345 of the Code of Criminal Procedure 1898 enacts provision for compromise for the compoundable offences. So we have limited scope for compromise in respect to criminal cases. Now, in my opinion, there are few reasons which are the main obstacles for mediation in Bangladesh. They are non-cooperation of the lawyers, ignorance and absence of trained mediators, lack of mediation centers, change of mentality, and no specific law for mediation like Arbitration Act 2001. It is true that in our country, the lawyers do not want to cooperate with the court about mediation due to fear of losing their income. My suggestion is that a standard amount of fees for the lawyers may be fixed for mediation for a better result. Public awareness is also need to be created for promoting mediation. Additionally, legal aid officers in the district court can also work as a cell in informing people about the benefits of mediation. Further, we need to build mediation center in every district to overcome the problems of mediation. Next, adequate training for mediators and arbitrators should be arranged from time to time. More steps should have to be taken to train the lawyers. Then they will be encouraged to be professional mediators in addition to their legal practice. We know that judiciary of Bangladesh is overburdened with nearly 4 million cases, and the number is mounting day by day due to a number of factors, including inadequate numbers of judges in terms of pending cases, procedural formality and complexity, poor logistic support, and corruption are the main reasons for backlogging of cases in our country. Therefore, we can easily understand the importance of promoting mediation in our judiciary to reduce the huge backlog of cases. Now, after 52 years of our independence, no one can deny Bangladesh has made tremendous progress in various social and economic indicators. Our economy is developing very rapidly, bringing its business into close contact with the outside world. Many foreign companies are now investing in Bangladesh. Therefore, effective steps towards alternative dispute resolution is needed to make Bangladesh an investment-oriented country. Also, it is the high time for Bangladesh to be a signatory of Singapore Convention for solving cross-border disputes. The father of the nation, Bangabandhu Sheikh Mujibur Rahman, wanted a change in the traditional judicial system of Bangladesh by introducing alternative dispute resolution. However, we can show respect to him by fulfilling his dream only by promoting ADR successfully. Dear participants, my advice to you is that you should bear in mind that after being qualified as an accredited mediator, you have to act fairly, impartially, independently, and maintain the confidentiality. Further, you have to honor party autonomy, avoid conflict of interest, act in accordance with the agreed principles and rules by applying judicial mind, in particular, maintaining utmost integrity and sincerity and should have the intention to do justice. We all are aware about common quotes in judicial domain said by William E. Gladstone that justice delayed is justice denied. Also, Martin Luther King Jr. said, injustice anywhere is a threat to justice everywhere. Every citizen is entitled to have access to justice. Delayed justice even sometimes fails to give proper remedies to a winning party. We all have to keep in mind all these courts for our judicial system and do job properly to open the door of justice and ensure it for all. Now, before I wrap up, I would like to put the famous words of President Abraham Lincoln, the United States of America, emphasizing the profound significance of mediation, said that discourage litigation, persuade your neighbors to compromise whenever you can. Point out them that nominal winner is often a real loser in fees, expenses, and waste of time. With these remarks, I conclude my speech and express my sincere thanks to the guests from overseas for their valuable speeches and my heartfelt gratitude to the organizers of BIMS for arranging such a meaningful training programs. Further, I feel honored and privileged to hand over. I hope all of you enjoyed the training program. Best wishes for all of you. Once again, thanks you for listening me with patience.
Thank you so much, sir, for your kind words. Definitely. We wish you a very safe and comfortable journey, Justice Mittal. A big round of applause. It's absolutely okay. She has to take her flight and probably will get a bit delayed. I would now like to invite the speaker of the evening, Mr. Arif Khan, who is an advocate with the Supreme Court of Bangladesh and also a trustee member of the Vishwa Sahitya Kendra. Sir, please.
A very good afternoon. Thank you very much, dear respected presence and audience here. I truly appreciate and welcome, heartfelt welcome from me for the trainees who completed such a long hour of training so successfully and have received very well-deserved and well-earned certificates. So, completing a training, such a rigorous training, so successfully and then receiving certificate is truly a very big achievement. So I want to congratulate and welcome you for such a wonderful achievement. So today's valedictory session, as you see, that all the host of stars are there on the dais. Particularly, I want to take this opportunity to mention my teacher, direct teacher, which means I took lessons from him, Professor Dr. Mizanur Rahman sir, who is present here. And it is such an honor. It is really impossible to express in words that my, youthful icon, Mizan sir, he was a star and he is a star still now among the law students across the universities. We studied law under him in Dhaka University, but he is a teacher for the nation. He is also recognized as a teacher for the nation because he has been awarded as the best law teacher of South Asia. And I'm sure that he is equally competent to be the best law teacher of the world too, I believe. So it is really an honor, sir, to share stage with you. And not only Professor Dr. Mizan sir, Honorable Justice Kuran Joseph, who is the gold medal awardee of this ceremony, Honorable Justice Mustafa Jaman Islam, one of the very highly distinguished and very learned current justice of our Supreme Court, Honorable Justice Ishwar Prasad Katiwala, His Excellency Mr. Ganesham Bandari, Honorable Justice retired Gita Mittal, Mr. Shah Monjurul Haq, our advocates leader. Unfortunately, he did not be present here today. Mrs. Madeline Kevin, Professor Dr. Mizanur Rahman sir, as I mentioned already, and Master of the Ceremony and distinguished audience. I want to mention very specifically Mr. S.N. Goswami, senior advocate, and his tireless effort. You know, when this ceremony is organized, actually, it takes, you know, too much of pain, you know, time, coordination, and diligence to organize a, you know, international cross-border ceremony like this. So I understand that, sir, you have been through so much for organizing such an international event. I will be speaking a little bit in hybrid language, since most of the audience here also Bengali speaking language. So I will be speaking in English and also a little bit in Bangla, so that I can really be understandable actually what I want to say. Because traditionally, what about mediation, importance of it, and what are the best qualities of mediators, all have been so well spoken already. It will be simply unnecessary for me to repeat those things. But I want to attract your attention to a very specific and very extraordinary aspects of mediation for Bangladeshi people or for Bengali people that we are present here. But before going into that information, let me also share another very emotional aspect. I have become emotional seeing so many Nepali participants today in this session, because Bangladesh has a very special gratitude to Nepal. It is because of our language. Okay, I don't know how many of the Nepali friends are aware of this, but let me tell you that we did not know before 1906, we did not know that Bangla. I mean, what is the age of Bengali language? Okay, so on that year in 1906, one of our very distinguished scholars visited Nepal, visited the library of the King of Nepal, and discovered very, very important literary documents, which for the first time in their history proved that our language, which is Bangla language as you speak, it is 1,000 years old. And those literary documents were for the first time discovered and were the definitive proof of the origin and evolution of our language. So all those manuscripts are lying, you know, in the Nepalese, King's library, and those were preserved only to give us this proud moment to know that what is the age of our language. So Nepali friends are very welcome, and we are truly indebted to them. So the point of mediation, as I was saying, that we have a Bangladesh and the Bengali people has a very special anthropological and sociological connection to the mediation process, because it is not merely a tools for, you know, adjudication or for dispute settlement. It is also innate. It is also very inherently involved and mixed with our character and our behavior, our living, our societal aspects and everything. Why I am saying this is that any dispute should be settled through mediation because it is peaceful. It is not a very, you know, new phenomena that should be adopted or should be learned for the first time. Rather, it is so intimately, you know, ingrained with our societal manner and behavior. আমাদের বাংলা ভাষা যে কয়টা ভাষা থেকে এসেছে, বাংলা ভাষায় আপনারা জানেন অনেক অন্য ভাষার শব্দ আছে। এর মধ্যে অন্য আরেকটা ভাষার নাম হলো অস্ট্রিক ভাষা। তো অস্ট্রিক ভাষা প্রি-আরিয়ান ভাষা। প্রি-আরিয়ান ভাষা মানে হলো আর্যরা যখন এই ভারতীয় উপমহাদেশে এসেছে, আমাদের রেসের সাথে আমাদের ভাষার সাথে আর্যদের অবদান আছে। তো আর্যরা এসেছে আজ থেকে ২,৫০০ থেকে ৩,০০০ বছর। অস্ট্রিকরা এই অঞ্চলে বসবাস করতো এরও আগে, তার মানে ৩,৫০০ থেকে ৪,০০০ বছর আগে। এই অস্ট্রিক ভাষার কিছু গুরুত্বপূর্ণ শব্দ আমরা কিভাবে নিশ্চিত করি যে বাংলা ভাষায় এখনো অস্ট্রিক ভাষার শব্দ আছে? কারণ কিছু অস্ট্রিক ভাষার কয়েকটা শব্দ হুবহু অবিকৃত অবস্থায় এখনো বাংলা ভাষায় ব্যবহৃত হয়। এটাই প্রমাণ করে যে আমাদের ভাষা অস্ট্রিক ভাষা দ্বারাও প্রভাবিত। যেমন লাঙ্গল শব্দ, লাঙ্গল শব্দ অশ্লীল ভাষায় ব্যবহৃত শব্দ, যেটা এখনো পর্যন্ত বাংলা ভাষায় অবিকৃতভাবে ব্যবহৃত। আমরা যে পণ পণ বা কুড়ি ভিত্তিক যে গণনা করি না, 2 পণ 3 পণ 1 কুড়ি 2 কুড়ি, এই কুড়ি দিয়ে গণনার যে সিস্টেম, এই সিস্টেম অশ্লীল ভাষা থেকে আমাদের বাংলা ভাষায় এসেছে। এবং অশ্লীল ভাষাভাষীরা এই অঞ্চলে বসবাস করতো আজ থেকে 3.5 থেকে 4,000 বছর আগে। অস্ট্রিক যে জনগোষ্ঠী এই অঞ্চলে বসবাস করতো, যাদের থেকে আমরা ইনহেরিট করেছি, আমরা বাঙালিরা এসেছি, আমাদের বাংলা ভাষা এসেছে, ওই ভাষায় পঞ্চায়েত প্রথা ছিল। এটা এখন বিভিন্ন গবেষণায় সুপ্রমাণিত। যদি ওই ভাষায় পঞ্চায়েত প্রথা থেকে থাকে, পঞ্চায়েত প্রথা কিন্তু ইটস এ মিনস অফ মিডিয়েশন, এবং এটা কিন্তু সোসাইটি মানে দ্বারা এটা সবসময় গঠিত এবং সোসাইটি ইনক্লুড। তো এই যে মানে মিডিয়েশনের মধ্য দিয়ে, পরস্পর আলোচনার মধ্য দিয়ে মানে সামাজিক বিরোধের মীমাংসা করতে হবে। এই বিরোধের মীমাংসার এই সিস্টেম, এই যে উপায়, এই উপায় আমাদের ঐতিহাসিকভাবে, আমাদের সোশিওলজিক্যালি এন্ড অ্যানথ্রোপোলজিক্যালি আমাদের রক্তের মধ্যে আছে। কিন্তু নানা ব্যবস্থার বিবর্তনের মধ্য দিয়ে মডার্ন কোর্টস এন্ড জুডিশিয়ারি উদ্ভব হয়েছে। তাও আবার বাংলাদেশে যে বাংলা অঞ্চলে আধুনিক কালের যে কোর্ট, একটা এজলাস থাকবে, ডায়াস থাকবে, বিচারক উঁচু জায়গায় বসবে এবং বিচারকটা আর্গু করবে, এইরকম আদালত তৈরি হয়েছে 1772 সালের পরে। তার মানে 300 বছরের কম ইতিহাস আমাদের যে ফর্মাল যে কোর্ট সিস্টেমে। এর আগে কিন্তু মিডিয়েশন ভিত্তিক বা এরিয়ার ভিত্তিক সমাজের বিরোধের মীমাংসায় কিন্তু সবথেকে বেশি ছিল। ফলে কোন একটা সোসাইটিতে, কোন একটা ভাষায়, কোন একটা জনগোষ্ঠী, কোন একটা জাতির মধ্যে যদি মিডিয়েশন বা পারস্পরিক সম্মতি এবং আলোচনার মধ্য দিয়ে বিবাদের মীমাংসা যদি তার আচরণগত, তার ব্যক্তিগত, সামাজিক, দৈনন্দিন বেঁচে থাকার মধ্যে এরকম একটা স্ট্রং সোশ্যাল এন্ড কালচারাল এলিমেন্ট হিসেবে থাকে, সেই সমাজে বা সেই জনগোষ্ঠীর মধ্যে মিডিয়েশন খুবই কার্যকর একটা প্রতিষ্ঠান হিসেবে, খুবই সফল এবং খুবই একটা বড় প্রতিষ্ঠান হিসেবে উদ্ভব হবে হওয়ার কথা। ফলে বাংলাদেশের মিডিয়েশনের গুরুত্ব এবং মিডিয়েশনের প্রাসঙ্গিকতা অনেক বেশি। এবং আপনারা যদি দেখেন যে মিডিয়েশন আমাদের এরকম একটা বিশাল কালচারালি এবং লিঙ্গুইস্টিক্যালি একটা এত বড় একটা হেরিটেজ, যেটা হাজার হাজার বছর ধরে আমাদের সমাজে চলে আসছে, এটাকে আরো ইনস্টিটিউশনালাইজ করার জন্য, এটাকে আরো প্রচার প্রসার এবং এটাকে আরো সমৃদ্ধ করার জন্য আমাদের কনস্টিটিউশনাল অব্লিগেশন আছে। কারণ কালচারাল এবং যে হেরিটেজ থাকে, কালচারাল হেরিটেজকে রক্ষা করার কিন্তু কনস্টিটিউশনাল অব্লিগেশন আমাদের আছে। আমাদের সংবিধানের 23 নম্বর অনুচ্ছেদ যদি করেন, সেখানে বলা আছে, আমি কোট দিচ্ছি, রাষ্ট্র জনগণের সাংস্কৃতিক ঐতিহ্য উত্তরাধিকার রক্ষণের জন্য ব্যবস্থা গ্রহণ করিবেন। এই যে রাষ্ট্র জনগণের সাংস্কৃতিক ঐতিহ্য উত্তরাধিকার সংরক্ষণ করবে, প্রোটেকশন করবে, প্রিজার্ভ করবে এবং এটাকে বিকাশের জন্য ব্যবস্থা করবে, এই কনস্টিটিউশনাল অব্লিগেশন কিন্তু আমাদের সংবিধানে আছে। এবং মিডিয়েশন কিন্তু আমাদের সমাজ এবং রাষ্ট্রের জন্য এবং ভাষার নিরিখে এরকম খুবই গুরুত্বপূর্ণ একটা কালচারাল হেরিটেজ, যে হেরিটেজটা উই মাস্ট প্রিজার্ভ, উই মাস্ট এক্সারসাইজ এন্ড উই মাস্ট ফ্লারিশ ইট। As I was saying that mediation as a cultural element or as a sociological element, as an anthropological element is very much innate in our societal being, in our combined memory, in our collective living. Therefore, in a society like us, Bangladesh, and a language like we speak in Bangla language, since it is so ingrained in our daily life and living, mediation as an institution should be more firmly established, practiced, and institutionalized in Bangladesh. BIMS is a very famous institution, and the training program that BIMS has conducted, 40 hours training program, I think is a very much useful undertaking to that path, which will try and which will definitely very fruitfully contribute to institutionalize mediation as a societal organization, and we all will be benefited, very immensely benefited from mediation practices and mediation procedural activities. I thank you very much. I thank you, S.N. Goswami sir, again, and I thank you from the core of my heart for all the organizers whose name I am not even aware, but I'm sure there are many who are very, very closely involved with organizing such a successful international global mediation conference and valedictory session. So thank you very much. I thank you again for inviting me and giving me this opportunity to speak a few years.
Thank you very much, Advocate Khan. Those were very inspiring words, specifically to know that as a Bengali myself from India, that our language basically makes mediation present in our DNA. So, going ahead with the evening, I would like to now invite our guest of honor, Honorable Justice Retired Ishwar Prasad Khatiwara, Supreme Court of Nepal. He has served as the Justice in the Supreme Court of Nepal. He has also served as the General Secretary of the Judges Society. Justice Khatiwara began his career as a section officer at the Judicial Service Training Center in 1983 and served as the government attorney from 1986 to 1993, after which he was appointed as the District Court Judge in 1993. Later, in 2005, he was promoted to the position of the Court of Appeals High Court. On 1st August 2016, he was appointed as the Supreme Court Justice. Sir, please grace the dais and inspire us with a few words. A big round of applause.
Esteemed Chair, Professor Dr. Mizanur Rahman, Honorable Justices present here, His Excellency Ambassador Mr. Ghanshyam Bhandari, learned senior advocates and advocates, distinguished participants, mediators from the regions, ladies and gentlemen. I am extremely grateful and honored to have been invited to this important forum. I am also very grateful for the hospitality of my host. It is my first time in Bangladesh, but your warmth has made me feel at home so far. In addition to your wonderful hospitality, this opportunity to participate in this forum has also been an enriching experience for me. I have greatly benefited from intelligent and thought-provoking remarks and idea sharing in this August gathering. I am also eagerly looking forward to the discussions from the experts in the days to come. It is hard to imagine a society without disputes. In fact, disputes are not always bad. Many times, disputes serve as a motivation or reasons for progressive transformation of a society. Creativity often develops in the face of the challenges and the differences. In this sense, dispute and their resolution are essential for the establishment of long-term peace. One can easily argue that the human civilization is filled with differences and disputes in various nature. It is equally apt to note that one of the major achievements of our civilization has also been creative, intelligent, and a practical dispute settlement method. Of course, when we see the brewing tensions, war, political, social, or economic differences around us, it is easy to be apprehensive toward our achievement in dispute settlement. But when we devote time energy and the resources in understanding the philosophical, political, social, economic, and legal endeavors in the field of dispute settlement. I feel we have reasons to be encouraged by the development in dispute settlement process. These days, it is common to use alternative dispute resolution mechanism in a variety of disputes. In fact, in so many areas of law or practical life, we are habituated to use and practice ADR. Courts or other formal dispute settlement institutions do not anymore see ADR as a competitor. Courts are realized ADR as an important tool to strengthen even the court's authority and role. ADR sometimes also sought to mediate unreasonable or impractical expectations from the court system. In a sense, both formal and informal mechanisms of dispute settlement are no more alternative to one another, but are complementary. Perhaps this is a significant development in the practice of ADR in the recent years. Although the South Asian region has rich history of peaceful settlement of dispute, and mediation has been a part of the social heritage in the countries of the region. Compared to formal mechanism of dispute resolution, it is only recently that states have started to consider the significance of informal mechanism of dispute resolution. Nepal began the practice of mediation only in 2004. That too purely at the initiative of the court. The Supreme Court of Nepal amended the district court rules to include provisions relating to mediation in relation to the cases already sub judice at district court level. After 2 years, the concept was introduced at all tiers of courts. Since the initial phase, when we on our own accord started mediation practice, presently we have been able to build relatively comprehensive legal provisions and institutional structure supporting mediation. At the center, we have the Mediation Council, which operates as a regulating body to promote institutionalize and regulate functioning of mediation. The Council has been working hard to mobilize and enlist the support and contribution of stakeholders and experts to promote mediation. We have also attempted to lend hand to expansion and the development of mediation services through monitoring, research, and process innovation. Additionally, we have mediation committee in each court in the country. In local government, we have separate body responsible for mediation. The Mediation Act of 2011 and the Mediation Rules of 2013 are the main body of law that regulates and promotes mediation in Nepal. The Mediation Council, which is responsible for the broader guidance of mediation practice in Nepal, was established by the Mediation Act of 2011. The Council is broadly engaged in supervision and regulation of mediation-related activities in the country. Additionally, the Council has also drafted related policies, guidelines, training manuals, mediation training syllabus, and so forth. The Council has also been taken note of international developments in the field of mediation and has made recommendations to the government to domesticate international practices and the developments. The Council has recommended the government to accede to the Singapore Convention on Mediation. Another important milestone that demonstrates the evolution of mediation and its general acceptance is the recognition of mediation by the Constitution of Nepal. The Constitution of Nepal, promulgated in 2015, recognized and encouraged the use of mediation as a dispute resolution mechanism. In addition, the 3 tiers of government defined by the Constitution also promote mediation values. 753 local governments that have wide range of competencies to administer governance, provide services, and make law have become an important host for effective mediation practice. Politically and constitutionally empowered local governments have been keen and to a large extent effective in resolving many disputes at the grassroots through mediation. I personally think it is an important thing for the growth of mediation value in Nepal. I also think the active engagement of local governments in mediation process helps to democratize, refine, and simplify the process of alternative settlement of disputes. In Nepal, as you might know, the most recent political transformation is marked by the end of the decade-long armed conflict. Transitional justice, therefore, forms a vital part of the post-conflict constitutional transformation. Unfortunately, we have not really been able to establish and implement meaningful post-conflict transitional justice system so far. It is in this context, as we are seeking ways and a means of employing mediation in achieving transitional justice. In general, there are encouraging signs that promises broad application and role of mediation. But it is also true that the practice and the culture of mediation is still encountering a number of challenges. Poor quality of training, limited mediators' qualifications, and lack of monitoring are some of the challenges that we have felt that have affected the achievement of full potential of mediation. The general lack of priority of the government in this area is another challenge. Particularly in case of Nepal, government's investment in mediation is not proportionate to the value, role, and the trust placed on the process by the law and the Constitution. There are also continued limitations in the understanding and the faith in the process of mediation. This is also affecting the effectiveness of mediation. To this end, we are eager to learn from other societies and the jurisdictions and understand wide philosophical discourse. We hope we can also become an example of best practice that the world can benefit. For this, it is essential that we continuously engage with one another and share our experiences and knowledge. It is in this context too, the mediators training organized by the Bangladesh International Mediation Society is timely and significant. I am so glad that you have included participants from the region, including Nepal, in this training. I am confident that this training has provided a much needed mediation to the mediators and would also assist mediators of the region to become even more effective in their respective works. I wish all the best to the participant mediators for their continued endeavor to engage in mediation and serve the cause of peace and justice in the region. I would also like to extend my heartfelt congratulations to Justice Korean Joseph and Gita Mittal as well on being awarded with the gold medal today. Also, I would congratulate to all the participants for successfully completing the mediation training. Once again, I would like to extend my gratitude to Bangladesh International Mediation Society and its chairperson, Senior Advocate Tamarendra Nath Goswami for the invitation and for organizing this important program. Thank you all.
Thank you so much, Honorable Justice Khattiwala. Your words of wisdom has really inspired us. Next, for the evening, I would like to invite guest of honor, His Excellency Mr. Ghanshyam Bhandari, who is the Ambassador of Nepal to Bangladesh.
Thank you. Chairperson, Professor Dr. Mizanur Rahman, Chief Guest of the program, Honorable Justice Mustafa Jaman Islam, Bangladesh Supreme Court. Guest of honor, former Justice of Supreme Court of Nepal, Honorable Ishwar Prasad Khattiwala. Gold medal recipient from the today's program, Honorable Justice Korean Joseph. Former Justice who has just left us, Honorable Gita Mittal. Guest speaker, Senior Advocate Mr. Saha Manjurul Haq, Advocate Mr. Arif Khan, Madam Madeline Kimi, and officials of BIMS. Most importantly, the chairperson of BIMS, Mr. S.N. Goswami, distinguished participants of the training, ladies and gentlemen. Namaste, Assalamu alaikum, and good afternoon. There is a saying when politicians and professors and the experts of a particular field speak, you find yourself in a very awkward position to come and say something. I think I'm one of the very odd men out today because I do not belong to this legal field who can talk confidently and conveniently about mediation and the legal practices at the court and outside. But there is an advantage of being one speaker, so I can refer to what the previous speakers have said and make a couple of points and bore you maybe a little bit. So thank you for this opportunity. At the outset, I'd like to thank and express my deepest gratitude to Bangladesh International Mediation Society for inviting me to be a part of this program. I thank BIMS for hosting the participants from different countries, including from Nepal, for this tailor-made accredited mediators training course. I'm pleased to acknowledge that we have 12 participants from Nepal, including advocates and representatives from legal, government, civil society backgrounds, including the ones who were involved in the peace process. We call them peace activists. Distinguished guests, ladies and gentlemen, since I am here in front of you, first of all, let me say a couple of things about Nepal-Bangladesh relationship, about which I feel so comfortable to speak about. And then I will talk about today's program. As you might know, the roots of Nepal-Bangladesh relationship can be traced to times predating Bangladesh's emergence as an independent country, that is 1971. As was referred to by Mr. Khan earlier on, one of the incidents of how close and connected our societies and communities were with reference to the finding of Charzapur, one of the ancient scripts, Bangla of Bangla language, in the Royal Court of Nepal in 1608 by a Bengali scholar called Haraprasad Sastri. He was a PhD scholar at that time. He found in the Royal Court of Nepal, as Mr. Khan said, one of the scripts of Bangla language. You can go even back in as early as 11th century. Atis Dipankar, who was a Buddhist scholar of the time, in 11th century, he was on his way to Tibet from Bengal of the time, and he traveled to Tibet through Nepal, and he helped disseminate and spread the teachings of Lord Buddha in the Kathmandu Valley. So we have traces of such connections. I don't want to go into details, which is not actually the topic of today's discussion. But even after 1971, Nepal was one of the first countries to recognize an independent Bangladesh. We always say that the relationship between our two countries is as organic as the link between the Himalayas, the water towers, and the Bay of Bengal, the water reservoir. It is as natural as the rivers flowing between the Himalayas and the Bay of Bengal. Over the years, there has been a steady growth in the economic, cultural, educational, and people-to-people ties between the two countries. When we talk about academic trainings and exchanges, you may know that Bangladesh is one of the preferred destinations of Nepali students who come here to pursue higher education, most particularly in the medical field. We have about 3,000 Nepali students who are at different universities across Bangladesh, and about 2,500 in the medical field. These students serve as our cultural and educational ambassadors, bringing our societies and peoples closer. The training and exchanges, such as the one you have had on mediation over this week, will also help strengthen these excellent linkages and collaboration our two countries and societies enjoy. As an embassy, we would like to see more of such exchanges. Dear friends, I'm pleased to learn that BIMS provides trainings in the field of conflict prevention, peace building, and alternative dispute resolution. It focuses on mediation with legal officers and professionals at the center for enhancing their performance by ensuring an advanced legal education system is commendable. We all know, especially in the context of South Asia, given the uniqueness of our historical, social, and cultural realities, it is important to promote the practice of alternative dispute resolution and mediation. When it comes to the alternative dispute settlement mechanism in Nepal, I don't want to repeat what Honorable Justice Ishwar Prasad Katiwada so eloquently highlighted, the mechanism both in institutional and of course at the communal, at the society level we have in Nepal. But I would just like to state that I'm sure even the distinguished participants from Nepal also have shared in their country presentation over the course of the training how we evolve in terms of mediation and where we stand now. But I would just like to say that it evolved steadily, both in the form of an organic social practice and through legal arrangements. One can see its evolution from the traditional way in those early years of solving disputes to the codification in general laws, to community mediation, to its integration as an essential component, which happened in the last 2 decades of judicial process as stipulated in the Constitution of Nepal 2015. Mediation Council of Nepal is a premier framework to regulate, monitor, and supervise mediators. It has a wide range of mandates in promoting and regulating mediation in Nepal. There are similar mechanisms at the district and local level. Nepal's constitution stipulates that there shall be in each 753. Honorable Justice Ishwar Prasad Katiwada also highlighted this. And this is one of the landmark achievements, landmark provisions, I would say, in our constitution, which was promulgated in 2015, when it comes to the practice of sort of a quasi-judicial practice, including the one on mediation in our local government, which are 753 in number. we have a 3-member judicial committee under the convenorship of the chairperson, who is elected by the people. And under the vice chairperson, we have 2 other members. The main tasks of such committees will be to settle disputes under their respective jurisdiction in accordance with the law. Mediation, of course, is one of the important means of settling such disputes. Let me not go into the further details, but I'd like to take this opportunity to state that when we talk about training, sharing of experiences, and best practices, including on mediation, we must first acknowledge that the solution to our collective challenges and problems are largely available in our countries in South Asia. So the need would be to learn from each other, share the practices, work together, and find solutions through solidarity. I take this opportunity to congratulate all the participants who have taken part in this course and become accredited mediators from now on. I hope your career as you go forward will be quite well enriched from this course, and I wish you all the very best. Since there was the term, Honorable Justice Geeta Mittal was left talk about greeting in an inclusive way. I know the majority of the audience in front of me is a Bangla speaking audience, so let me conclude with my broken Bangla. সম্মানিত অতিথিবৃন্দ ও প্রিয় সুধী মণ্ডলী, নেপাল ও বাংলাদেশের মধ্যে বন্ধুত্বপূর্ণ সম্পর্ক রয়েছে। এই ধরনের প্রশিক্ষণ আমাদের মানুষ, প্রতিষ্ঠান এবং দেশকে আরো কাছাকাছি নিয়ে আসে। এটি মধ্যস্থতার মাধ্যমে মতভেদ নিষ্পত্তির দিকে মনোনিবেশ করে, যা বিশ্বের সমস্ত দেশের জন্য অত্যন্ত গুরুত্বপূর্ণ। তবে আমাদের দক্ষিণ এশিয়ার দেশগুলির যা আরো বেশি প্রয়োজন। আমি নিশ্চিত যে অংশগ্রহণকারীরা প্রশিক্ষণ থেকে শিক্ষা গ্রহণ করবে এবং তাদের পেশাগত জীবন তা কাজে লাগাবে। আমি বিমস এবং আপনাদের প্রত্যেককে সাফল্য কামনা করি। আপনাদের সবাইকে অনেক অনেক ধন্যবাদ।
Thank you so much, His Excellency, Mr. Ghanshyam Bhandari. Those last words in Bengali really stole the show, I would say. Now, I would like to invite the chair of the evening, Dr. Professor Miznaur Rahman, who is the former chairman, National Human Rights Commission, Bangladesh.
Your Excellencies, ladies and gentlemen, it's my profound privilege to stand before you and share some of my thoughts. But I understand that as the chair of the session, I'm not supposed to speak and make a long speech. So I'll be very, very brief. But nonetheless, I'll touch upon certain points. Well, one is, my association with the BIMS goes back to a number of years. But then in between, there was a huge gap. And today, once again, I am associated with BIMS, just like the joy of homecoming. I'm so happy to be at BIMS and with you, all the participants who have successfully completed this course on architectural mediation. Thank you very much. But, as I was sitting and you're receiving your certificates, I noticed that we're not too generous in recognizing and appreciating. So let us probably make a second effort in recognizing and appreciating you. Would you all please get very fast? Well, the second point is, you say, what is the best moment, the joyful moment, the pleasing moment, the rewarding moment in a man's life, in a person's life? When you see your child surpasses you, outgrows you. So I'm so happy today that my child, my student, Mustafa, is a chief case. What could be more pleasing for you? And I'm so happy. I'm happy that I am presiding in an event where participants are from different jurisdictions and mostly from Nepal. And I mention Nepal because I have a special connection with Nepal. I have been visiting professor to the Kathmandu School of Law for a good number of years. I have so many good friends in Nepal, including your former minister, Mr. Madhav Paudel, including the former Secretary General of SAARC, Arjun Thapa, including Professor at the Tribhuvan University, Rajit Thapa probably also. So you see, I have so many good friends, and the director of the Kathmandu School of Law, the former Attorney General for Nepal, my good friend, Professor Juboraj Sambhu. Well, Nepal is my second home. Probably I visited around 20-25 times, but well, Juboraj, surpassed me like anything else, which I can never compete with him because he has visited Bangladesh already 69 times. The only thing left for me is to get married to Bangladesh. That's what I want to tell you. However, what I want to say is, it's not only Bangladesh, but the whole of South Asia. We have this Confucian wisdom that in social relations, there cannot be total winners or total losers. This is something that was not taught to us by the white man coming from the West. It was inbuilt in our psyche. It is our knowledge. It is our homegrown philosophy and knowledge that we carried for centuries today. But then what happened? This is the white man who came under the guise of white man's burden and distorted the system of dispute resolution in Bharat. And I include Nepal in this, this nomenclature of Bharat in that sense, the whole of South Asia. They distorted it. They implanted or transplanted this litigation system where either, as the ABBA song goes, the winner takes it all. And the winner takes it, and one wins and the other loses, which was never the case with the Indian civilization. So we must go back to it. And if mediation through BIMS or to any other organization, whatever we're trying, I believe that it's simply our attempt to go back to the roots, to know ourselves, to go to our own civilizational, the cardinal principles of our civilization. And if we can achieve that, well, we can say goodbye to the West. Because, you see, it is the Western imposition of their ideas and philosophies and dispute resolution that led to the creation of what Ambedkar had called the broken man. We in South Asia, we all became the broken man. And we are looking for assistance and help from outside. So there's no alternative to relearning. In order, probably we need to, in Ashish Nandi's language, I must say that we first must relearn and then relearn. Relearn our own jurisprudence. It has to be an Indian, homegrown jurisprudence that was taught by none else than by my guru, whom I call my guru, is Professor N.R. Madhava Menon. It was taught to us by none else than, the saint judge from Kerala. And what's the name of the judge from Kerala? Absolutely, Mr. Krishna Justice Krishna. Those are the people who taught us what is there ingrained in the Indian system. If we believe in that, we can go back there. Then that is where mediation comes. Where there's, true understanding and negotiation, which is the best way of resolution of any dispute. Even when, let me just, I'll not make my speech, very long, I promise you, but in the 70s, in the late 60s and 70s, when there was the war in Vietnam, so North Vietnam and South Vietnam. One, backed by China and the other backed by the United States. And what happened? They were so much at enmity with each other that they wouldn't sit together face to face. So when they sat for negotiation, for talking to each other, so if, the ambassador, His Excellency is sitting like this, so the other from the other part of Vietnam, they would come and sit like this, facing the wall, just facing the wall, but not to face each other. That was the rate, the amount of hatred. But then they started talking. Both are talking to the wall. But at the end of the day, they turned. They started talking face to face, and the problem was resolved. So it is to negotiate. The human factor that is so important in the process of mediation. So I would just say that when you are talking about litigation or anything else, there is the Western concept of coercion. Coercion as the basis of law, the coercion sanctioned by the state. But in the Indian philosophy and civilization, coercion was never the basis of law. It was common consent or the consensus of the community. We need to go back to that definition of law, and not to the definition that law is the command of the sovereign, or that rubbish definition we have to start. We have to relearn and know ourselves, and that's the best way. And what Mr. Goswami has been doing with his tremendous labor and hard work is trying to bring all of us together so that we can talk to each other, we can learn from each other, and we can learn, even as citizens of the different countries of South Asia, to make this people-to-people contact, this friendship among the people, which is the best bondage that you can create. And nothing else can be a better security of a state than the respect, the mutual respect, love, and connection that people can create with each other. So thank you, Mr. Goswami. Thank you, BIMS, for inviting me to preside over the session. And I consider it to be a rare opportunity and privilege for me to be here with you. Thank you very much, and chocolate Mongolo.
Thank you so much, sir, for such inspiring words. Well, when you say that we really need to unlearn and relearn, I cannot agree more on that. I mean, that is something that we have seen and believed in, and probably we are trying to go ahead with that. Now, coming to the end of today's wonderful session, I would like to share my heartfelt thanks to, again, the Honorable Justice Retired Kurian Joseph, who was the former judge of Supreme Court of India and the recipient of the Gold Medal Award on Mediation. I would also like to thank our Chief Honorable Justice Mustafa Zaman Islam, Judge, High Court Division, Supreme Court of Bangladesh. I would also like to thank Guest of Honor, Honorable Justice Retired Ishwar Prasad Khatiwada, Supreme Court of Nepal. Guest of Honor, His Excellency Mr. Ghanshyam Bhandari, who is the Ambassador of Nepal to Bangladesh. Guest of Honor, Honorable Justice Retired Ms. Geeta Mittal, who was the former Chief Justice to the State of Jammu and Kashmir in India. Our guest speaker, Mr. Shah Monjurul Haq, unfortunately he could not join us. Our speaker, Advocate Arif Khan from the Supreme Court of Bangladesh, and also he's the trustee of Vishwasahitya Kendra. And of course, Ms. Madeline Kimei, the chairperson of BIMS Mediation Board. And our chair for the session, Professor Dr. Miznaur Rahman, who is the former chairman, National Human Rights Commission, Bangladesh. I also would like to share a special thank you to Advocate S.N. Goswami sir and all the office bearers of BIMS for their unwavering support and dedication, which has been the backbone of this event. Without your efforts, this training program would not have been possible. To all the participants, I commend you for the dedication and active engagement throughout this program. You have shown remarkable commitment to learning and improving your mediation skills. The role-playing exercises, discussions, and feedback sessions have all demonstrated your eagerness to grow and learn and excel as mediators. In the words of Nelson Mandela, I would say it is not our failure, but our ability to rise every time we fall that defines our true glory. As mediators, you will face challenges and setbacks. However, with the knowledge and skills gained in this training, I am confident that you will rise and meet every challenge with resilience and grace. Let us look forward to a renewed commitment to promote peace, understanding, and resolution in every conflict we encounter. Thank you once again to our esteemed guests, organizers, and participants for making this training program a resounding success. Thank you all, and I wish you a very best for the future endeavors. I would like to request all the participants to kindly come on the stage to take a picture with our esteemed guests, and then please go back and be seated for some refreshments. Thank you so much.